Welcome to this week's CollaborEAT Live. My collaborative team's CollaborEAT Live provides digestible content to both professionals and the public on a variety of topics relating to the collaborative process. Episodes consist of a variety of topics driven by our followers and our members. Topics range from ethical considerations, best practices, problem solving, marketing, specialized topics relating to the collaborative practice tools, and much more. CollaborEAT Live provides thought-provoking conversation and educational information about the collaborative process. This week's CollaborEAT Live will consist of all four of the My Collaborative Team founding members presenting on what is the collaborative process. Recently, our founding members held a 1-hour webinar on what is the collaborative process for those who don't know as much about the process and are learning or wanting to learn more. This is just a small snippet of that hour-long presentation.
I would like to welcome you all to our My Collaborative Team's webinar today about what is the collaborative process. All of our presenters today are co-founders of My Collaborative Team. I'm going to start by introducing to you what the foundation is of the collaborative practice. The founding principle for all of us is that families do not belong in the courtroom. When people that are seeking a divorce go to an attorney who primarily practices in the area of litigation, as we all know, the filing attorney files a petition for dissolution. Depending on what kind of attorney we have, they may ask for everything possible, from permanent alimony to sole parental responsibility or custody, depending on your jurisdiction, and a whole host of allegations that may include anything from spousal abuse to issues relating to the children in an effort to get sole custody for their client, and are essentially declaring war on the other spouse. Service is done either at home or at work, which of course we know can be intimidating, particularly when it's done at work, and the parties end up before a judge. Those of us involved in the collaborative process believe very strongly that that is not the appropriate forum for resolving family disputes. The collaborative process, in our opinion, is the only appropriate forum for resolving most family disputes. At the core of the collaborative process is the party's right, the client's rights, we don't call them parties actually in the collaborative process, to self-determination. It's interest-based. We have a disqualification clause in our collaborative participation agreements, which require that if the parties end up in litigation, the attorneys and the neutrals, both the financial and the neutral facilitator, depending on where you live, we have to be disqualified, which means that once they leave the collaborative process, we are out of the case. We cannot go forward in working with them in the litigated process. I can tell you that the IACP several years ago did an analysis of the cases that come through the collaborative process. The statistics are overwhelmingly in favor of the collaborative process. We have 86% of our cases reaching full agreement and a 2% spousal reconciliation. In the collaborative process, we attempt to keep it to a limited number of what we call full team meetings, which include the professionals and our clients. And then there can be separate meetings with the two neutrals if necessary, typically the neutral facilitator who works on the parenting plan at a much reduced rate than the attorneys would be doing it, and the financial neutral who's working on all of the financial pieces, both of which you'll hear more about when Ed and Jerry speak. The Uniform Collaborative Law Act was created to allow for a uniform system of practice for the collaborative law process in each state that adopts it. Its policy is to ensure the peaceful resolution of disputes and the early resolution of pending litigation through a voluntary settlement process. The collaborative process is a unique, non-adversarial process that preserves a working relationship between the parties and reduces the emotional and financial toll of litigation. The collaborative process also has provisions in most statutes that allow for cases that involve domestic violence. And it's very carefully spelled out under what circumstances and how the attorneys assess the case for domestic violence, and under what circumstances we can actually continue with the case in which there has been domestic violence. The key component to it at all times is client self-determination. And in working with our clients, we keep in mind that this is their process, not ours.
Okay, thanks, Becky. Hi, everybody. So my name's Carolann Mazza, and I've been practicing family law and particularly out-of-court process options for about 12 years now. So early on in my practice, I had the great good fortune of having a mentor who introduced me to the collaborative process while we were working together on a horrible case. It was a post-judgment case where two people, probably doing the best they could, father turned to alcohol to handle his, his stress, mom very controlling, and as her world spun out of control, and they were playing tag or tug of war really with their 14-year-old daughter, and it was really awful. The lawyer on the other side said to me, have you ever heard about collaborative practice or the collaborative divorce? And I hadn't. And from there on, I attended a training and I was sucked in. It really appealed to me because it never felt right. Going into a courtroom and trying to make one parent look bad while I tried to make my client look good, because the reality is both parents most likely in most cases are doing the best they can. So I started training, started marketing myself as a collaborative attorney, and pretty much marketed myself right out of family law. And then I realized that being a collaborative family attorney is being a family attorney. Except my focus was out of court, and still is to this day, out of court process options with an emphasis on collaborative law and collaborative divorce. What I've discovered, and the reality is that 9 out of 10 people who ever came into my office and who come into my office say that they don't want to go to court. They don't want to fight in court. If they have children, they say they want to put their children at the top of their decision making. They want to make sure things stay comfortable and safe and healthy for their children. Because ultimately the divorce process is a bunch of decisions that have to be made, a number of decisions. And when I talk to clients about who's going to make those decisions, the judge who's a stranger, or the clients who I do believe are experts, they just need a little help maybe to talk it over, to articulate their feelings, articulate what their needs are. They often want to make those decisions. I talk to clients about the collaborative process and collaborative divorce and the team as providing resources to help them make their decisions, because we in the collaborative world know that they're capable of making those decisions. It's just that the conversations become very difficult because emotions are high, and we often revert back to old patterns of dealing in divorce. So I talk to clients about how the team is there to help them communicate more effectively and efficiently. I also obviously talk to them about the collaborative practice, recognizing that not every family is the same and not every one-size-all result works for every family. And yet in court, that's what clients get, pretty much a one-size-fits-all result. The judges are boxed into the law. No matter what state you're practicing in, the judge has to follow the law of that state. Whereas in the collaborative process, the sky is the limit, and the team is there to help people create options that work for them.
I think we all recognize that there are only 2 issues in family law that parents or spouses have to decide on, and that the court has to decide on. One is the allocation of either assets or liabilities at the dissolution of a relationship, and if there are children, time sharing. And I think, as Becky and Carolann have said previously, family law or family law litigation is really about emotional litigation.
People's emotions get in the way of making good decisions, and oftentimes attorneys get a bad reputation, perhaps deservedly so, perhaps not, of fueling the litigation. And there are all sorts of processes that go on. And I think we also recognize that judges in the family courts, most of whom don't like to be there because of the emotional expressions that go on. In a litigated case or in a litigated divorce, mental health professionals have what I would call a peripheral role. The litigation is like a chess match. There's a black team, there's a white team, there are a number of players, but the ones that get to make the decisions are the kings and the queens and their lawyers. And the mental health professional is either a therapist for the children or a therapist for one of the parties. And oftentimes attorneys don't want their clients to go to a therapist or a counselor, lest those records become discoverable, although their clients probably should be seeing somebody, at least for support. Or the mental health professional is appointed as a custody evaluator. Here in Florida, we call it a social investigator, who interviews the parties and the children and makes some recommendation to the court as to what an appropriate time-sharing arrangement might be. And then if there's enough money left to litigate, another expert, mental health expert, is hired to challenge the court-appointed experts' procedures and or recommendations, and the court case proceeds forever. Unlike a chess match, the collaborative process is more like an engineering team getting together to craft some product that will serve the family, in which there isn't a black team and a white team, but each member of the team at different times has different responsibilities, either to their team members or to the parents. And so the mental health professional serves as using his skills in a number of ways. More often than not, to facilitate the process, although in some jurisdictions or some states, it is the financial professional who's the facilitator of team meetings. But more typically, it's the mental health professional who facilitates, who steps back, and who, like the financial professional, gathers information about the family, where the financial professional is gathering information about financial aspects of the family. The mental health professional is gathering information about parties' dynamics, about their wishes, about their emotional state, and is there at the team meetings or sometimes in individual meetings, either with the attorneys and their client or the client alone, or sometimes the attorneys together, to help manage the emotions that may come up so that everybody stays on track.
The collaborative process is embedded in what is known as an interest-based process and interest-based negotiations. In interest-based negotiations, as Becky said, the party's self-determination is the most important. Their goals, their fears, their needs, their wants. Our role in the collaborative process is that of educator. We gather all the information that's needed. And here's another key thing to the collaborative process from the client's point of view. As a neutral financial professional, I only do the work that is needed to provide the clients with the information they need to make an informed decision. I don't do work that's not necessary. You don't see these requests for production where we asked for everything in the world for the last 3 years. Most of that stuff's not even utilized. So we don't determine what records we need until we have a general feel for what the clients need. And that really is what drives us. So as a neutral financial, my role is to determine and with the clients what information is needed, provide them with that information in an understandable format, be there to answer their questions, their concerns, make sure I understand their goals, and help them get to that goal. My opinion in the litigation world, forensic accountants, we're paid for our opinion. When I get on a witness stand, I thank God don't do it anymore, but when I used to get on a witness stand, my opinion is all that mattered to me, and making sure that I sold my opinion to the court based on the information that I have was my primary role. That's not true in the collaborative process. In fact, my opinion in the collaborative process almost doesn't matter at all. I can give advice, I can use my experience, I can answer questions, but ultimately it is the clients who are responsible for the ultimate decisions. I go into cases, or I'll go into a team meeting, I don't have pre-filled out forms. We may start with a form, but we actually build the equitable distribution and build alimony scenarios and various options in our meetings. So that is one of the major shifts of the neutral financial professional. We are there to help the parties reach their goal. I would encourage everyone to look at all forms of keeping clients, keeping these people and these families out of court. I want to thank my fellow founders for today's training. We hope you all enjoyed it. We hope you got good information.
Thank you for joining us at this week's CollaborEAT Live. If you would like to be a guest on our CollaborEAT, please email info@mycollaborativeteam.com or reach out to us here on social media. Thanks again for viewing and have a great day.